Conflicts of interest in real estate occur when a licensee's personal, professional, or financial interests could compromise or appear to compromise their ability to act solely in the best interest of a client. The Arizona Department of Real Estate, ADRA, and Arizona courts have made it clear that transparency is the foundation of public trust, and any situation in which a conflict might arise must be disclosed immediately. And in writing, the guiding principles are found in ARS, Section 32,215.3, Subsection A, Paragraph 3, and Commissioner's Rule R4-28-1101, which require honesty, fairness, and full disclosure of all material facts, as well as addressing conflicts of interest. A conflict of interest can be direct or indirect. A direct conflict exists when a licensee has a personal stake in the outcome of a transaction. For example, if a licensee is purchasing a property for themselves, representing a family member, or has ownership in the company selling the property, that relationship must be disclosed in writing before entering into any agreement. Indirect conflicts may arise from financial or professional relationships that could influence the licensee's judgment, such as referring clients to a contractor, lender, or title company, in which they have an undisclosed ownership interest. Arizona law does not prohibit these relationships, but demands full transparency to ensure all parties understand the licensee's role and potential gain. According to R4-28-1101E, a licensee must disclose in writing any situation in which they or their immediate family members, defined to include spouse, parents, siblings, children, or business partners, have an interest in a transaction. The disclosure must occur before or at the time of entering into a binding agreement. Failure to do so may result in disciplinary action, including license suspension or revocation, under ARS Section 32-2153A3. The key test is whether a reasonable person would feel that the licensee's objectivity might be compromised. An example of this obligation can be seen in a scenario where a real estate agent lists a property owned by their brother. The agent must disclose this familial relationship to all parties involved in the transaction. If the agent also represents the buyer, this dual relationship further increases the appearance of bias. By proactively disclosing the relationship, the agent allows both parties to make informed decisions about representation and avoids any perception of deceit. Another common example involves a licensee selling their own property. Arizona law, through ARS Section 32-2156B, requires that licensees disclose their license status in writing in any contract for the sale or lease of real property in which the licensee has an interest. This disclosure ensures that the buyer understands they are negotiating with a licensed professional who may have superior market knowledge and access to information not available to the general public. AACR 4-28-1101E1. The same rule applies if a licensee is buying a property for themselves. The seller must be informed in writing that the buyer holds an active real estate license. Conflicts also arise when a licensee refers clients to service providers, such as mortgage brokers, title companies, inspectors, or contractors under the Real Estate Settlement Procedures Act, RESPA. Federal law prohibits kickbacks or referral fees for such recommendations unless fully disclosed and in compliance with RESPA guidelines. In Arizona, this principle is reinforced by R4-28-1101A, which demands that licensees act with honesty and fairness in all transactions. For instance, if an agent refers a buyer to a home inspector who happens to be their cousin or business partner, that relationship must be disclosed to the buyer, even if the inspector performs quality work. The lack of disclosure could lead to a complaint to ADRE, or civil liability for undisclosed self-interest. One of the most serious forms of conflict occurs when a licensee represents multiple parties in a transaction without full disclosure and consent. This scenario, often referred to as dual agency, is permissible under Arizona law only when all parties have provided informed written consent through the consent to limited representation form approved by ADRE. Without this consent, the licensee risks violating their fiduciary duty of loyalty and confidentiality to one or both parties. Courts have consistently upheld that the failure to disclose dual representation constitutes a breach of fiduciary duty. R4-28-1101F. The Arizona case of Haldeman versus Gosnell Development Corp., 1993, provides an important precedent. In that case, a broker failed to disclose that he had a financial interest in the property being sold to his client. The court ruled that the non-disclosure was a breach of fiduciary duty, and the client was entitled to damages. This decision underscores the critical importance of disclosure. The law does not forbid personal interest, but it punishes non-disclosure. Timing of disclosure is equally crucial. The disclosure must occur at the earliest possible moment, ideally before a contract is signed, money is exchanged, or advice is given that could influence a party's decision. Late disclosure can be just as damaging as none at all, as it may appear deceptive or manipulative. The most effective practice is to provide written disclosure as soon as the potential conflict is identified. Retain a signed copy in the transaction file and ensure all parties understand its significance. In practical terms, a licensee should ask themselves 2 questions in every transaction. Could this situation give the appearance of divided loyalty? And would all parties still feel confident in my objectivity if they knew all the facts? If the answer to either is uncertain, written disclosure is required. This standard not only complies with R4-28-1101F, but also demonstrates professionalism and integrity. Review summary. Conflicts of interest occur whenever a licensee's personal, familial, or financial relationships could interfere with their duty to act solely in the client's best interest. Arizona law under ARS Section 32-2153A3 and R4-28-1101F requires that such conflicts be disclosed in writing before entering into any contract or agreement. Common examples include selling property owned by a family member, representing both buyer and seller without consent, referring clients to businesses in which the licensee has ownership, or buying or selling property for oneself. The rule is simple: disclose early, disclose clearly, and document everything. Discussion. Why must a licensee disclose a conflict of interest in writing? Answer. To ensure that all parties are aware of the licensee's personal or financial stake. Maintaining transparency and compliance with R4-28-1101F. If a licensee sells their own home, what must be disclosed to buyers? Answer. The licensee must disclose in writing that they hold an active Arizona real estate license before entering into the purchase contract as required by ARS Section 32-2156B. What happens if a licensee refers clients to a business in which they have ownership without disclosing it? Answer. It constitutes a conflict of interest and may lead to disciplinary action under ARS Section 32-2153A3 for dishonesty or misrepresentation. Closing remarks. Conflict of interest disclosure is not about avoiding personal involvement in real estate transactions. It is about maintaining ethical boundaries and ensuring full transparency. The integrity of Arizona's real estate profession depends on the public's trust, and that trust is upheld through openness, honesty, and written disclosure of all potential conflicts. When licensees act transparently, they protect not only their clients, but also their own professional reputation and license.